broad work of the coalition. And for the coalition that I just mentioned, our mission and objective is to see that no woman in Uganda dies out of unsafe abortion. Our keynote speaker is Asia Russell, who is the executive director of Health Gap, and she has been in Uganda for the longest time. She has been very passionate around access to medicine and also access to sexual reproductive health rights, especially around issues of abortion in terms of the legal and policy and the implication of that to having women and girls access the rightful sexual reproductive health rights. She will be taking us on, but we have also panelists or respondents who will be speaking to the same issue. We have our dear Mr. Moses Mulumba, Dr. Moses Mulumba, who is a lawyer with special interest in international human rights. He is currently the Director General of Afya na Haki, which is an organization that is focused on research and training and sexual reproductive health rights. And he is the founding member of the founding executive director of the Center for Health, Human Rights and Development, which is CEHAD. And he has spearheaded many legal and public health successes in health and rights, and led various programmatic and community interventions towards social justice in health. The other respondent is Christopher Sengoga, who is representing Rwanda, and he is the Executive Director of Health Development Initiative, and he has worked with RR Associates and company advocates as a legal associate. He's also been a senior legal researcher at Great Lakes Initiative for Human Rights and Development, and also worked with Oxfam on gender justice program, where he developed training manuals and produced gender research surveys. Ladies and gentlemen, those are our esteemed keynote speaker and respondents to this discussion, and I know that we are in good hands, and I encourage everyone to participate. At this juncture, I will invite our keynote speaker, Asia Russell, who was also a founding part of the founding members of the Coalition to Stop Maternal Mortality Due to Unsafe Abortion. Over to you, Asia.
Thanks so much, Anne. I hope everyone can hear me well. Good afternoon to everyone. It's such a joy to be on this panel with leaders from Uganda and from the region who are truly at the forefront of fighting for health justice for everyone and ensuring the comprehensive right to bodily autonomy, to sexual and reproductive health and rights, to information, to really the fullest enjoyment of health rights for women and for their communities. I just want to start by saying that I've been privileged to learn so much from so many people who are on this call today, and that's why it's so important that we bring our heads and our hearts together at a moment of inflection, frankly. So my name is Asia Russell, as Anne mentioned. I'm the executive director of an advocacy organization called Health Gap, and I've been in a position over the last more than 10 years now to be able to collaborate with CEHAD, with many, many groups on the call, in forming and supporting coalitions of activists working to eliminate preventable maternal mortality and morbidity in Uganda, and working to extend access to safe and legal abortion, as well as other comprehensive sexual and reproductive health and rights services through advocacy, through strategic litigation, through mobilizing to combat and to expose the harms of abortion stigma that women in Uganda and across the region and around the world suffer and labor with every single day. It's also important to mention that we come to this moment at a time when the colliding pandemics of preventable maternal death and morbidity from unsafe abortion, from other causes, are colliding with COVID-19, and where we see, particularly for young people, not only in Uganda, but around the world, across the region, we see young women having truly suffered grave injustices from our duty bearers over the last 2 years, in the form of lost protection from violence that comes from schooling, lost access to contraceptive services, lost access to HIV preventive and treatment services. All of these things interconnect with the need for timely access to information, to comprehensive sexuality education and services. And we just see the vulnerabilities of our young people intensify and stretch to the breaking point, to a point where I think for many people, many practitioners working in this field as advocates, as service providers, as civil society leaders, as lawyers, judges, magistrates, we really find ourselves angered and dismayed at the extent to which our communities are being, frankly, abandoned and have been abandoned. So what do we do now? So my job in opening this important, esteemed webinar is hopefully to provide some hope. I'd like to provide a little bit of context about what's taking place in the United States, what we expect to come from our Supreme Court. So the Supreme Court of the United States is the highest court of the land. I'm an activist, not a lawyer, so that's my first caveat. You'll hear from learned experts in the law after me, but my job is to provide a sense of setting the table for what's coming from the Supreme Court of the United States, and considerations as advocates as we map what we're fighting for and why after the federal law, the highest law in the United States that establishes a right to an abortion, gets overturned. So first, a little bit of context about what is coming next. As people might know, about 49 years ago in the United States, Roe versus Wade was decided in favor of the right, although not without caveat, to an abortion in the United States. After that, before that point, abortion in the United States had been severely restricted and criminalized. And the decision set out in Roe versus Wade in 1973 required that until the point of fetal viability, which was generally established to be at about 23 to 24 weeks in a pregnancy, women had a defined right to an abortion. So what that means functionally is that if a state or a jurisdiction within the United States continued to prohibit abortion before that point of viability, they would be defying the law. They would be doing something that was unconstitutional. The Constitution of the United States sets out the highest law of the land. So it was an incredible decision by the court, one that was precedent setting, incredibly important. And also one that as soon as it was decided in 1973, I would argue immediately those who opposed the decision started defining a plan of attack. And over the last almost half a century, they have been very successful in slowly and steadily implementing a playbook that chips away at this precedent of Roe versus Wade. And I want to talk about that a little bit because as advocates, the mistakes of the United States should not be repeated by any other country. And that's where the hope comes in. We have in Uganda, in the Great Lakes region and beyond, the opportunity to prevent the shortcomings of US approaches, and in fact, to teach the US and to teach other parts of the world how to create a much more robust human rights and health justice oriented response to criminalization of abortion, and how to build a rising tide of a demand for health justice, so that we don't, not only do we not repeat the mistakes of the United States, but we turn the page, and we create such a deafening demand for equality, for health justice, that we no longer have to fear going back. That's the hope. And that's what we have to plan for, because otherwise we become internally reflective, and we, quite frankly, are only mired in despair. And there's no place for that. There's so much work to be done and so much progress, still to be made. My perspective is that we've reached another point of inflection, and in any disruptive or consequential moment, there are both setbacks that are severe and life-threatening, but there are also important openings and portals for growth and for establishing new precedent. And that's quite firmly the moment that we're in. So it's incumbent on all of us to lead and to act. And that's, I hope, the spirit that you walk away from this webinar with today. So what we expect truly at any moment, starting from the coming days right up to the end of June, is for the Supreme Court of the United States to hand down a majority ruling that overturns Roe versus Wade in their ruling on a case called Dobbs versus Jackson Women's Health Organization. Jackson is a city in the state of Mississippi. We know this because there was a leaked text in May circulated that appears to be the draft decision by the court in that matter. It's never been the case that a decision in contemplation has been leaked from the Supreme Court before, but luckily this one was, so that the country can see, and the world truly can see, what's at stake. What will happen after this decision is made is something very devastating. So right now, the prediction is that roughly half of the states of the United States will rapidly criminalize access to abortion, primarily through criminalizing the act provided by a health worker, although this will also open up opportunities to criminalize the seeker of an abortion and others who support a person in seeking an abortion as well. So quite literally, over a very rapid period of time, roughly half of people in need of abortions will no longer be able to get access to them. This will primarily be taking place in the geographic south of the United States. So southern states where, as I'll describe, those states have been at the forefront of eroding access from the very day that Roe versus Wade was decided. Importantly, just as in Uganda and in the rest of the world, inequities in access to safe and legal abortion are not random. They are concentrated among people who are already subjected to severe disadvantage in health service access across multiple lines. So in the United States, for example, we see women who are at greater risk of poverty being at much greater risk of poor maternal health outcomes, at risk of needing and not being able to obtain access to an abortion, and at greater risk of other severe health inequities, whether around diabetes, around HIV, around other essential health services. Why is that the case? Because health rights in the United States are not defended, protected, or promoted reasonably. And in fact, the United States is the only country among high-income countries where maternal mortality has been increasing. And it's not increasing for everyone because the United States is a country where racism against Black and Brown people is also an epidemic. What we see is that for Black American women, the condition of pregnancy is life-threatening. And that's not because of any fault of their own. It's because of racism in American society, unfortunately, and the way in which racism plays out in the provision of healthcare services. So why is this important for our discussion of the imminent and terrifying, frankly, overturning of Roe versus Wade? Because since the time that Roe was established by the Supreme Court, those who are opponents of access to safe and legal abortion have been obstructing other barriers, because the highest law of the land established this precedent, the precedent that is about to be overturned. They cleverly devised other ways to obstruct access, aggressively, methodically, and in a very disciplined way. And I draw this out because I think it's very important for us to understand just how strategic and talented abortion foes have been. So in the face of the law of the land establishing access to abortion in the United States, opponents of abortion set up other restrictions. They set up restrictions in funding abortion. So there is no safety net that provides free access to healthcare services in the United States for everyone. The US is also singular in that regard. Virtually all high-income countries have a form of health insurance that is single payer, that enshrines access to health services as a right, as a subsidy, as an aspect of the welfare state. The US does not have that. And abortion foes recognized that primarily middle class and affluent, primarily white women would be able to pay their way to get access to abortion services. And so they quickly moved through Congress, that is the legislative branch in the United States, to close off the subsidy of abortion services through healthcare services for indigent people, Medicaid services. So in barring that access, they closed off the ability for people who are more likely to be impoverished to be able to obtain this essential service. So already you see a contradiction. If the highest law of the land establishes that there is a right to an abortion, then it's reasonable that every other branch of government would create a policy environment that enacts this law. But we saw the opposite. We saw the legislative branch close the subsidy for poor women. Now, in the North, in New York, in Massachusetts, in other states where there was more liberalization around access to health services, states still continued some degree of subsidy, but it didn't matter. Already, two parallel systems were being created where more impoverished women were being told they had a right, but this right was being defied day in and day out, not because they were different, but because they were more likely to be impoverished, not to have disposable income. And we didn't see national reproductive healthcare movements, so pro-choice organizations in the United States, aggressively fighting this closure of access for the most needy people. And that was, I think, mistake number one. That was a huge mistake and should never be repeated. Reproductive healthcare organizations should have been on the front lines of fighting for access through Medicaid and combating that effort in Congress, which was truly a war on poor women and truly hypocritical. Then we see after that point, the barriers being set up at the level of policy. So suddenly, abortion providers in the United States had to contend with tons of bureaucratic red tape to be able to provide services in clinics, so that little by little, even though there was a right enshrined in the Supreme Court, we saw states where functionally there were almost no abortion providers because they couldn't afford to keep their clinics open, because there were so many restrictions about how abortions could be provided in their states or in their counties or in their cities, that abortion access just dried up. There were deserts, so that women had to somehow, early on in their pregnancy, with no money, find hundreds, if not thousands of dollars to travel across state lines to be able to get access to a safe abortion. And mind you, this is while Roe versus Wade is in effect. So we could see for years and years the threat coming down the pipeline, but now it's turning into the reality. So this situation where for some women, even though the right to abortion in the United States has been enshrined in law, it has not been realized in fact, is now going to become even more intensified. Now, I'm an activist. I don't believe in doom and gloom. I believe in pragmatism, and I believe in change, and I believe in hope. And I think we have reason for hope. So that's the United States. That's what's coming down the pike. And I want to share that with you because of three things. One, we need solidarity with people of the United States. We need North-South and South-South solidarity. We need you to extend the movement for health justice into the United States. You need to recognize that the time for US exceptionalism has long since passed, and that the mistakes that the US justice system is making should also teach all of us a lesson about the humility that an imperial power, frankly, like the US needs to have. But that's not the only reason I'm talking with you today. Importantly, many of the national precedents, the regional cases that are actually, being argued right now across sub-Saharan Africa and other parts of the world point to Roe versus Wade as decided law. That's an important precedent. We know that Roe is invoked over and over again, as it should be, in many of our legal strategies, our advocacy strategies, because it's important law. It sets out a right under the 14th Amendment of the Constitution of the United States for what's broadly thought of as a right for a woman to make this private decision with her health worker to an abortion. So it follows that the overturning of this case then creates a fissure for all of those legal efforts. And importantly, today, we have to discuss what we do about that and how we ensure that that does not create a vacuum and that does not create weakness in our effort to ensure health justice for everyone, including women who seek access to safe and legal abortion in Uganda, in Rwanda, in Kenya, and around the world. And I think it's very, very possible. And in fact, it's incumbent on us to recognize that this creates the opportunity to redefine how we talk about this right. A weakness of the United States was that the right to abortion was set out as basically a civil protection, a pretty narrow protection. It was not set out as a human right, as an aspect of fundamental human health rights and a more robust understanding of health justice, that communities must be able, no matter how individuals feel about a procedure, if we believe in one another's indivisible human rights, we also have to believe that any person has the right to decide whether and if they are going to become a parent. That is, start a family and support a family for the rest of their lives. That's not the approach that Roe v. Wade took. They took a very narrow ruling. And at this point, the extension and, can I say, the infrastructure of Roe v. Wade has been stretched to the point of breaking. And that's what's happening in June, is that infrastructure will finally break. That is very destabilizing. It's very scary. It has direct consequences for our global struggle for access to reproductive health justice, but we cannot allow it to stop us. So that's the second point. Importantly, we have to map and redefine our strategies, because to the extent that any of our arguments were relying on Roe versus Wade as settled law, that has changed. And we cannot give fuel or comfort to those who would undermine access to reproductive health justice in the overturning of Roe v. Wade. So we have to reconfigure, we have to pivot, we have to be resilient, and I know that we can. The opposition in across East Africa and around the world will certainly use this as a moment to assert their power, assert their supremacy, but we will not allow them to do that. And that's, why do I say that? Well, I say that because of my third point, and that's where I'll close, because I think today we really have to have a discussion about what we do next and how we take leadership from particularly Sub-Saharan Africa and Sub-Saharan African experts. So let's take a look at the rest of the world. Ignore the United States for a moment. There's a rising tide for the last, I would say, decade in the opposite direction of the overturning of Roe v. Wade. Why do I say that? Because there have been scores of countries since the mid-noughts, so since about 2015, where abortion access has been expanded against all odds. And I would say against many experts in judicial process, in legislative process, in human rights, who have said, oh, that will never happen. In fact, you look to Latin America, you look to Europe in the case of Ireland, you look to Sub-Saharan Africa in the case of Mozambique, in the case of Ethiopia, several other countries, important rulings that have just taken place in Kenya. And the tide has been most firmly, what's been called globally a green wave, in the opposite direction, toward more expansive access to the right of a woman to reproductive health justice, including access to safe and legal abortion. Now, this is not 100%. We also see Poland much more firmly aligned with what's taking place in the United States. We see Nicaragua, we see other countries where I would say there is still an exceptional movement in the minority. Let's say the US movement is the movement of the minority. So it's not 100%. There are exceptions in all directions, but without a doubt, there is a firm wave led by brave, creative, indefatigable young people and legal experts who are on the front lines every single day, demanding that women be given the authority to choose how to form families. And I would argue the way that they and we together are fighting for access to safe and legal abortion, as well as comprehensive sexuality education, as well as access to contraception, as well as access to universal health care for people who are starting families and need the protection and security of a welfare state that provides them the security of health justice. They have imagined a continuum of healthcare services. I think an error in the United States was a very individualistic framework that centered on the civil rights rather than the human right. Because you see, access to abortion is not in distinction from access to healthcare services for those who do seek to start a family. It's in a continuum. Of course, all of us know that as health justice activists. No matter what your personal views are of abortion, your moral views, and your moral certitude, functionally, it does not matter. Abortion has existed since time immemorial and will continue long after we are all dead. The reality is, will a woman die or suffer or be thrown into poverty because of an abortion or not? And all of these decisions exist in the continuum of the life, the everyday life that all of us choose and that all of us carry out every single day. We know that as received wisdom, but that's not the way the battle for access to abortion gets defined or described every single day. And that's the other problem of the United States. In refusing to define abortion as a fundamental aspect of health justice, ultimately, if you believe that people need the safety and security in order for economies to succeed, in order for the rule of law to be enjoyed by everyone equally, then you have to believe that ultimately women need to be able to decide whether and how to start families. And I think the beautiful thing that's happening with the green wave and with the work being done by the leaders on the speakers on this phone call is that they understand that. And that's how they're defining access to abortion. And in fact, some of the ways that liberal pro-choice organizations in the United States have defined the fight for abortion have really been guilty of this over-individualization rather than looking out to communities and to societies in a way that I would argue is very important and consequential in countries like Uganda. And taking a cue from that approach. So that's where we have to be humble, learn lessons, and ride the green wave in the United States, frankly, and start fighting back for a much more comprehensive definition of access to safe and legal abortion as part of an indivisible struggle for reproductive health justice and struggle for health justice overall for all people, not only behind closed doors, only for women, but to acknowledge that everyone benefits, no matter your gender, no matter your sexual orientation, no matter your level of education or affluence, everyone benefits when women are given the freedom and the liberty to decide whether and how to start families. And it's because so many people in the United States refuse to fight back publicly and openly, really bought into the stigma and shame of abortion, that we really have ended up in the place where we are today, where this tremendous precedent of Roe versus Wade is about to be taken away from us. We should not blame ourselves, but we must act. We must write a new playbook, be led by the activism and expertise of people in the global South, and we must not give up hope. And that's finally where I'd like to conclude. The one measure of hope that I think we must pull from the very consequential and very devastating overturning of Roe versus Wade that will come is that we cannot be distracted. There'll be jubilation across the world by those who oppose the equal rights of women and those who oppose, health justice. Please do not be distracted. Do not be distracted. Do not find yourself in despair. Take a few days to reflect, to recommit yourself to the struggle, but do not despair. We need you, not only activists in the United States, but we need you around the world not to be distracted, because ultimately the majority of people around the world believe in this fundamental vision of health justice that is indivisible from the vision of the ability to choose whether and how to start a family. So know that you have the majority on your side. This is a consequential setback, but it is not fatal. And what we must do is prepare. What we must do is ensure that for our national and regional legal strategies, that to the extent that Roe versus Wade no longer can be leaned on as settled law, we must replace it with something else. We must find other ways, and we shall, because ultimately we will win. I know that that's the case. We shall win, but only if we learn these lessons and act with decisiveness and with solidarity and with ambition to put the reality and the vision of health justice, reproductive health justice, and the uncompromising right to abortion first and foremost. There's no other way around it. I really welcome the feedback and questions and comments of all the experts on this call, and look forward to a robust discussion. Thanks so much, Anne. I'll hand it back over to you.
Thank you, Asia. Thank you for that elaborate context that you have given us in terms of implication both for the US but also the rest of the world in the event that the case of Roe versus Wade is overturned. In your address, you have called us to solidarity, and I think that everyone on call can see that there is a need for us to stand in solidarity with the US, with whatever is happening, because it trickles down to at our national level and regional for the efforts that we have put in terms of progressing on sexual reproductive health rights, especially the right to safe abortion. You've also challenged us to think of what we need to do, the efforts that we should put forward in terms of seeing that the efforts that we have made do not get eroded away by this, and also you've given us hope that there are other ways in the event that the case is overturned. There are options that we can place our efforts on, but the fight is not over, because the decision, again, what leaked is a draft. We haven't yet got the final decision, so there's still hope for us to continue fighting, and you have encouraged us to be resilient, because health justice matters. For those who joined a little after Asia had given the context before when she started, just to remind you that Roe versus Wade is a case that was decided in 1973 by the US Supreme Court, and the two important things that the case decided on was that the US Constitution provides a fundamental right to privacy that protects a person's right to choose whether to have an abortion, although there was also a caveat on it where the court said abortion rights, but the abortion right was not absolute. So that's where we are coming from, and this conversation is really to see if this case that has been a foundation for some of the progress that we have made in our countries, if it is overturned, what does that mean for us? Asia has done a good job to show to us what this means for the rest of the world, but also for the US. But Asia, to just pose a question to you. First of all, I know that before I hand over to the respondents. I know that, of course, the global policies impact on our national laws. They trickle down, just like we saw the global gag rule and the implication of that on sexual reproductive health rights in our countries. And I know that partners in the US have been pushing for the permanent repeal of the global gag rule. And my question is, why now? Since you are on ground, probably you would have insights on why now this case would be, that the judges, the Supreme Court judges, would be seeking to overturn this case after almost half a century. That's 49 years after the case has been decided. Why now? You could provide for us some insights before
Yep,
we go into the rest, to listen to the
definitely.
respondents.
And I see also a question in the chat. I do not think that decriminalization in Uganda will be near to impossible because of the overturn of Roe versus Wade. I think it gives the opposition, it gives those who really, 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 really want to see a very restrictive environment, it gives them a little more power and a little more, let's say, it turbocharges their arguments because it's a victory for them. And anytime in a long struggle, when different powerful duty bearers get a victory, we know it gives them some momentary communications, power. There'll be lots and lots of media about it in Uganda and beyond. We know that that will happen. Don't despair. It doesn't mean anything is impossible. It makes it more difficult, I'm sure, but it doesn't mean it's impossible. There always is a way. And we all exist in a solar system. The US government, the US is not the sun. The whole world does not revolve around the United States. This is important. And we must, as advocates, assess and plan, but also recognize that the US is like a fish swimming in the opposite direction of the fish of the rest of the world. And that doesn't negate the harm that this decision will cause. I am not minimizing that, but I also want to take a look at the broader context. So Anne asks two questions. What does this mean for the global gag rule and for global investments from development assistance by the United States? And also kind of why now? So on why now, as people might know, there have been multiple conservative young justices. The Supreme Court appointments, a lifetime appointment, which is very retrogressive, frankly. And there have been a number of extremely fundamentalist Supreme Court justices appointed by Donald Trump. So those on the leading edge of fundamentalist opposition to reproductive health justice, not only abortion, but reproductive health access, as well as LGBTQ rights, as well as access to comprehensive teachings about race and racism, because they're very much aligned in my country, at least. Those folks saw an opportunity. So they worked through our maze of courts, our judicial system in the United States, in order to trigger the opportunity to challenge the precedent of Roe versus Wade. They saw a moment where it made sense to do that, and they struck, because now they can see a road, whereas before there was a more divided court, or a court, as in the case of Roe v. Wade, that ruled 7-2 in favor of this access to caveated abortion rights. They saw the opposite in the face of the new court, where there is more conservative fundamentalism, I would argue, and this opportunity among these young, extreme justices who are appointed for life. So that's why it's happening now. And then on the point of the global dimension, we are still very much in the middle of a fight to permanently overturn the global gag rule. Right now, the global gag rule has been repealed by the Biden administration. It's set out by executive order, typically, and There is a push to try to make sure that that is enshrined permanently, at least in law, until someone would overturn it in law. But right now we have a very divided Congress, so it's been hard to get that voted by the majority, even though the majority of Americans agree that US development assistance should not be tied up through this requirement. But the global gag rule essentially requires any receiver of development assistance not to talk about abortion as a possible intervention, not to use development assistance to fund abortion, but just to talk about it. Already the global gag rule has been repealed by the Biden administration, but the issue Anne is talking about is whether and how it would come back with a Republican administration or with a next president. Importantly, there's also a move afoot to repeal something called the Helms Amendment, which is much more extreme. The Helms Amendment prohibits or limits, actually, technically, the investment of US development assistance for health directly in the funding of abortion. And we believe firmly that that kind of restriction shouldn't exist. The Helms Amendment makes no sense and should be repealed. But right now that prohibition is in effect. Beyond that, functionally speaking, development assistance would not become more restricted as a result of the overturning of Roe versus Wade. But that decision does give a ton of ammunition and power. I would argue temporary power. We shouldn't be set off track completely to those who do not support reproductive health justice in the rest of the world outside of the United States, including in Uganda and in the Great Lakes region. Thanks. I hope that answers your question.
Thank you so much, Asia. Yes, it does. Thank you for that additional insight into why now, and also at least giving us hope on the GGR and the progress therein. We'll go to the respondent, and before I invite the next respondent, just to note that one of the things that Asia mentioned was that overturning this case would be a war on poor women. And I know that in our region, in the global south, most of the people who suffer access or who have challenges in accessing sexual reproductive health rights are people of low income, are people, women and girls who cannot afford health care. And for us to achieve health justice, we would need to be mindful of the fact that even the social dynamics play in terms of denying other people for access to sexual reproductive health, while others may easily access. So I'll bring in our respondent, Mr. Moses Mulumba, the Director General of Afya na Haki, who will give us context in light of the Ugandan context in terms of the implication of this overturning or the possibility of overturning this case. Welcome, and over to you, Mr. Moses Mulumba.
Thank you so much, Anne, and I want to thank all the people attending the important conversation this afternoon and morning for those that are not in our jurisdiction, or evening. I want to thank Asia for giving such a very enabling context and keynote that informs the response that we are going to be making. I think I'm going to get a little bit legal. I'll dive in a little bit to the facts. And Anne, I'm sorry, I will not necessarily discuss what this means for Uganda in the few minutes that I have, but whatever I talk about I think if you think through it, gives you the context and why we need to be worried or why we need to take more action. As one of those countries that are part of the global South. I think that I will not assume that we all know the facts of the case, but those facts and the history of abortion, not just in the United States, becomes important in a conversation like this. For many years, before we started seeing legislations around abortion, abortions were treated as common law offenses. When you look at the history of abortions, you see that much of the actions around regulating abortions were targeting the people who are performing the abortion, not the woman themselves. So it was considered as an action without a lawful purpose in common law. Of course, they came back to revisit that position in Roe versus Wade. And I think one of the justices indicated that there were no firm foundations for criminalizing abortion against a woman in English common law. And again, that's very important in terms of the context. When you think about it, and when you see how history has been happening, the purpose of regulating or banning abortions have been around 4 issues. We seem to run with 2 only, but 4 critical issues. First is the preservation of the life of the fetus. One of the groups runs very fast towards that direction. And then secondly, the preservation of the life of the mother. And in most cases, the contested issues around litigating abortions follow those 2, the clarification or non-clarifications, or the clarity or non-clarity around, the position on the life of the mother, which later on they confuse and they call the health of the mother. They have different considerations. And then the life of the fetus. But there is a third component, which is the deterrence effect. Like any other criminal system, the question of deterring is big. So I think they have also used criminal offenses against abortion to actually use it as a deterrent to stop women. The offenses may not be targeting the woman, and it may be targeting the person performing the abortion in history. But the effect is to deter the acts of abortions. And then lastly, they have argued that there is need to prevent injuring the mother to sort of disable them from having a child in the future. So these are some of the arguments that have always been fronted historically. But again, in history and the cases that have been brought up, it's been very interesting that the women were not arrested. There were no common cases of arresting women. Even when they were arrested, they were treated as pieces of objects that give evidence against those that performed the abortion. So they arrest the woman, if they have at all arrested the woman, to interrogate them, to give information. But in most cases, it's been the health workers that have been targeted in the circus of regulating abortions. So in a way, the woman finds herself in a difficult situation, that many of the offenses are not against them. They are against the people that have performed, but she becomes a subject of the discussion. So you cannot run away from the woman herself, even when you argue that when you have a law on abortion, you're just targeting the action. In fact, post-colonialism or during colonialism, we saw that the laws that were later developed from common law practices went away from just targeting the health professionals or those terminating pregnancy to now begin including the woman herself. Now, in the US specifically, they faced a lot of challenges historically because they work with a jury system. And in many cases, the juries that were constituted on offenses, when they brought offenses against women, they refused to convict women for abortions. So even the jury system found it easier to target the health worker and not the woman. Now, the groups that are pushing for a life line of arguments found this very, very difficult. And in fact, I think in the 70s, there is a famous case where hospital staff went and reported a woman, I think she was called Shelley, reported her for terminating pregnancy. Again, when she was being convicted, as in one of the rare cases where the women were convicted, she received a 2-year probation and had options of even going back to her place. So you could see that in the history, there is denial that actually women are being targeted. But the consequence inevitably targets the woman. And in some cases, the woman herself ends up being targeted. So in a build-up to Roe versus Wade, Sarah Weddington, who was an advocate, like some of you on the call, begins to think about how they can deal with the issue of making abortion as medically necessary in some situations for women. Because there were those cases where you do not necessarily have to wait for the woman to terminate pregnancy or request for it, but the system should be enabling for the woman when she needs it. So that's where the story of Roe versus Wade happens. And I think in a quest to have a test case, 2 cases come up. The first case that they landed on, Sarah and her colleague Linda Coffey, they landed on a family where a lady had a neurochemical disorder, which would impact on her life if she had a baby. But at the same time, she never wanted to abstain from sex. So in such a condition, do you wait for the pregnancy to happen and then you deal with the legal orders as they are? I think it became one of the issues that would be considered as important moving forward. But then they had a big question. How do you take a case before the courts when the woman who has taken it is not personally pregnant? So they ended up with an idea of looking for an option of a lady that would pursue a case who was pregnant. And that's when now the famous Jane Roe comes up. And when they landed on her facts, I think when you read the history, the description of her as a white, young, pregnant woman made her a good candidate for these 2 test cases. So they ended up taking 2 cases. The one where the woman was not pregnant, but needed to actually have a safe space. And then the second one where the woman was actually pregnant. And when you read back to the facts of Jane, they are also quite interesting. But in reading the 2 cases and the arguments and the history of Roe versus Wade, where it comes from, there are very many important things that come up, which I think the recent conversations on reopening up Roe versus Wade would actually bring back, and which we thought were sorted. First, we do a lot of litigations ourselves, and you'll find that multiple cases are filed, just like the case in Uganda. We have constitutional petitions happening on termination of pregnancy, but they are going to be multiple. So some of the things that we pick out of these is the first action that Sarah and the colleague did of thinking about how Roe versus Wade would be argued together with a similar case, and therefore consolidation of suits that are of similar nature. There was a huge conversation in Roe versus Wade around consolidation of issues and what are the things that you need to think about if you have to consolidate a suit that touches on termination of pregnancy. So I leave that there, but I think that it is a very important thing to think about. Also, in the process of trial, of hearing the case when it finally reached the Supreme Court, I think the male dominance and the patriarchal society kind of statements also reflected very strongly. You know that the lawyer who was on the other side, Jay Floyd, has been described as a guy who made the most unpopular legal joke when he described himself as finding himself in a situation where he had to argue between two beautiful women. And according to his joke, where a man argues against two beautiful women, the beautiful women always have the last word. So when you look into it and think about some of the circumstances and the criticism that have come even out of the procedure itself, I think they remind us a lot about the nature of society that we have. And this is not just a society that is African or in low resource society, but society overall, and the kind of things that we have to deal with even in litigating very important issues. So finally, when the case came for hearing, there was debate, and that debate has continued on whether there should be abortion, to what extent that abortion should be, who should decide on the legality of abortion, and to what extent should the moral or religious views inform abortion. So we witnessed it both in the court, as Roe versus Wade was argued, but also in the advocacy efforts and outside the courtroom. And this continues to dominate the conversations. And it's something we need to think about. Are we ready to open up these questions? And I'll be coming back to the text itself that was leaked. Does it open up the four fundamental questions? Whether abortion should be discussed at all, and to what extent should abortion be? Who should be deciding on the question of abortion? And that comes up repeatedly over and over again. And then the role of morals and religious views when it comes to abortion. So the reopening up of Roe versus Wade takes us back to some of those questions, which for a long time we thought have actually been sorted. So coming back to Jane Roe, the candidate of the case, so she's based in Texas, but the law in Texas makes abortions illegal, except when necessary to save the mother's life. And this is in 1969. Those that were there in 1969, I think the most prominent event in Uganda was the time that Pope Paul visited the country. But we were independent. So the world is opened up. So there are travels and therefore things that are happening all over the world are important. So she comes up, and part of the facts that are actually uncovered is that, you know, she's already a mother of three, but she finds herself in a situation where now the Texas law makes it illegal for her to actually have an abortion when she wants it, except in saving the mother's life. Now, this is very important because some of the laws that we have, including the law in Uganda and many other countries, talk about saving the mother's life. And what does saving the mother's life mean? Does the reopening up of Roe versus Wade take us back to these conversations on limitations of laws and laws that restrict access to abortion? in a fashion that the Texas law was actually doing. A panel of 3 judges eventually make a ruling that the US Constitution generally protects the pregnant woman's liberty to choose to have an abortion. And then this becomes a center of controversy, but also happiness and conversations for the last 40+ years that we've had. Now, within the case, there are interesting legal things that one needs to look at and think about, because the argument of the case was not based on the constitutional provision to have an abortion or the constitutional right to have an abortion, but rather the arguments of the case were based on due process, a clause that is referred to as due process, that is part of the 14th Amendment of the US Constitution. So that's very important, because as we argue elsewhere outside the US, we've not only realized the right to access safe and legal abortions through express provisions in constitutions on the right to access abortions. And that's a big question as they open up Roe versus Wade. Is it something that is coming up? Because in this Roe versus Wade, you see that the merits of the case are actually around privacy, which is part of the due process that the US takes as fundamental for their right. That's one issue to think about. Number 2, the court rightly, as someone has said, observed that this right is not absolute. It must be balanced with the government's interest to protect the women's health and prenatal life. Now, while Roe versus Wade has been praised for all the years and we need to preserve it, it had a caveat that actually the government still has an interest in protecting the women's health, but also the prenatal life. So we are going back to these conversations again, but also something to think about very deeply is the role that the Roe versus Wade bestows on the state, and just how much in some jurisdiction Roe versus Wade has been used by the states in a wrong way. Does the reopening up in one way give an opportunity for us to close that, as some of the justices were thinking? I think I leave it for us to think about. The third thing that was very important in this decision is the announcement of the trimester timetable. Trimester became prominent with Roe versus Wade, with the argument that first trimester, the government has no regulation whatsoever. What matters is that the termination of pregnancy is by a licensed physician. In the second trimester, the government protects the maternal health of the mother, but not of the fetus. So the regulation under second trimester follows that trend. And the third trimester, there is some regulation, and it introduces the question of saving the life of the mother. So it extends to both life and health. Now, we have continued to suffer with what the distinction between life and health means and what the courts would actually extend, or what the health professionals would tell us as situations of life and health of the mother. And this is the basis of many standards and guidelines. For many countries that have developed standards and guidelines, they are trying to implement the operationalization of the concept of the third trimester. I think the other point that is last for me, that was critical, the fourth in this judgment, is the pronouncement that abortion is part of the fundamental rights. On the one hand, it's not absolute, but it's a fundamental right. And that's probably a distinction that we need to think about with our constitutions. Do we argue that rights, when they are fundamental, they are absolute? cannot be taken away. Roe versus Wade doesn't seem to tell us that. In a way, when it says that the right to abortion is fundamental, as some of the justices pronounced, it equates the right to abortion to some of the fundamental rights that we have in the Ugandan constitution around torture, freedom from torture, freedom from slavery, a right to a fair hearing, and the right to habeas corpus, which are fundamental. And we therefore argue them in that way. So when they open up Roe versus Wade, and as I will be indicating later with our judges that follow the strict, sometimes interpretation of jurisprudence from other jurisdictions, what do those two mean? And do we make the distinction between them in our own context? So since 1973, when that judgment was passed, I think it has come back over and over. But in 1992, Planned Parenthood versus Casey makes a reaffirmation that actually the issues that were discussed in Roe versus Wade are important, but it overrules the trimester framework in a way. So trimester, we've continued to use it, and Roe versus Wade gave it to us, but one needs to look at PP versus Casey and what it actually replaces with the trimester framework. And then it also abandoned the strict scrutiny, which in a way, the second reason that I was giving that abortion is fundamental, that Roe versus Wade had provided, seems to be lost in 1992 when PP versus Casey was passed as a judgment. So again, in reading Roe versus Wade, we don't have to forget PP versus Casey and those two principles that it changes, which were very, very critical and important. Now, from 1992, the next big conversation is in 2021. And I think we're in the lockdowns, when, again, Texas came back to news with the Heartbeat Act, which outlawed abortions up until 6 weeks. And then the Oklahoma governor, who also signed on a similar law that was bringing back the same impact. So Roe versus Wade became a big discussion again, and its implications on the Texas conversations. And then later in 2022, in May 2022, when we saw the leaked opinion published by the Politico, where Justice Samuel Alito is actually writing the majority decision on overturning Roe versus Wade. And I think that this conversation needs to familiarize itself with what exactly that text is telling us and what the implication of that text is about. Now, this leaked text is a judgment from a case that is pending before the Supreme Court. And that's called Dobbs versus Jackson Women's Health Organization. In this case, Dobbs is challenging Mississippi's state law that bans abortions after 15 weeks. And that's that they are using the Gestation Age Act of 2018. Now, I must also rest your fears that when you read the history, the leaking of judgments in the US is not a new phenomenon. In Roe versus Wade, in 1972, the memo by Justice Douglas, before the final decision was made, was leaked and published by the Washington Post. So when it comes to issues of abortion, some of these are tactics, in my view, to either prepare us as a public for what is coming, but also one may argue that it's, you know, the new media things while in 1972 the leak was there, it's not shocking that we see this same action happening in this. Therefore, I have taken the liberty to look at the text. The text is huge, over 150 pages. But there are some paragraphs which I found very interesting, which we need to think about and their implications. And I'll end with the implications. The judges seem to argue that abortions performed after 15 weeks typically use evacuation as a procedure. And they argue in this leaked text that the use of this procedure for non-therapeutic reasons is barbaric and dangerous. And in fact, they describe it as demeaning for medical professions. I don't know whether in the current text where we've advanced in medicine, that kind of reasoning can still stand as a reason. Number two, and again, these are my own synthesis of what I have seen in the text. They argue that the law regulating abortion is entitled to a strong presumption of validity. So they don't see the value of us questioning or asking the validity of the law that is regulating abortion. And they want the populations to assume that in fact there is validity in that law. And there is a whole conversation on why they think that the presumption of validity is important in the context. I will quote them. They say, we do not pretend to know how our political system or society will respond to the decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is interpret the law. So that's a powerful statement in which the judges seem to say they don't care about what the political or society systems will look like. They don't care about the implications. And it's a pregnant statement that I think we need to think about in itself. And implications important in constitutional decisions. It's something that I leave on the table, as I indicated. And then lastly, what I pick from the leaked text is the judges say that they want to ensure that their decision is not misunderstood. In fact, they argue that they want to emphasize that their decision only concerns the constitutional right to abort and not any other rights. Remember, I told you that Roe versus Wade, when you look at it, based its argument mostly on other rights, especially on due process and the right to privacy. So in the leaked text, in overturning Roe versus Wade, the judges seem to say that unless the US Constitution has clearly provided for the right to abort as part of the constitutional provisions expressly provided for, it cannot be looked at in light of other rights which were used in Roe versus Wade. I think that that's very dangerous and could have serious implications. So I summarize what Anne could want as implications in the following lines. First, rights to safe and legal abortions can not only be got in express provisions of constitutions. I think the fact that due process and the right to privacy was argued to provide part of the basis for Roe versus Wade is very important for us, and including the constitutional petitions we are arguing, because we are arguing part of this in rights of women. So therefore, if rights of women in the Constitution does not say right to terminate pregnancy, and you read the Constitution in that way, it may be a limited interpretation. Point number two, which I found very important, is the mootness and the use of facts and the human face in cases. By the time the decision in Roe versus Wade was done, the subject lady had already delivered, had already given birth. So there was a high likelihood that they would say this suit has become moot it's no longer relevant for the non-lawyers, since the person who was suing wanted the law to enable her to terminate, and now she can no longer do it. We cannot proceed with the case. And this mootness is very important. Does the overturn of Roe versus Wade, especially in termination of pregnancy cases, when you use a human face to the case, becomes very important. Because, you know, the last time Sehad was litigating a successful case, it took 9 years. So if you're to litigate the current constitutional petitions on abortion, they are over 3 years already. So mootness is a question that was dealt with that I still find very important. The third point is the distinction they make between the 9th Amendment of the US Constitution versus the 14th Amendment. Because the 9th Amendment in the US Constitution is an equivalent of our constitutional provision, which says that if a right is not necessarily provided for in the Constitution, it does not mean that it does not exist. Now, the judges in Roe versus Wade did not follow the 9th Amendment. They rather followed the 14th Amendment, which is a proactive way in which you do not wait for the right to be provided or go to court and argue that this right cannot be argued in the other right. And again, I think Justice William made a very interesting finding that the right not to actually specifically enumerate the Constitution does not necessarily mean that it has been taken away. So it's a third point for those that are litigating sexual reproductive health and rights that we need to think about very strongly. There is a component which the Chief Justice then in Roe versus Wade, Justice Warren Burger, actually also raised. The question of certifying the termination of pregnancy by 2 physicians. It's one of the components that is in Roe versus Wade. Do we want to open up that conversation that actually you have to have a certain number of physicians to certify an abortion, or if you don't, then there are sweeping consequences towards that? I think it's one issue to think about very strongly. Now, what I have seen in the leaked text and the judgment, the dissenting judgment of Justice Byron White in Roe versus Wade, is the argument that courts do not have any role in determining questions of abortion. The role should be left to the people and the political process. In fact, in his dissenting judgment, Justice Byron seemed to argue that the judgment is an extravagant exercise of judicial power, of judicial review. And according to him, abortion should be left with the people and the political process. What he's actually arguing here is that the states, when they make the law, the Constitution, the Supreme Court has nothing to do with it. It's almost the same argument we are having on Constitutional Petition 16 here, when the state was arguing that it becomes a political question. So it's an equivalent of a political question doctrine, that once the executive has made a decision on how much allocations goes to the sector, the judiciary cannot question it. So once the equivalent of parliaments at the state have made a law, the judges should not entertain some of these questions. And in the leaked text, as they summarize the judges, they seem to say that it is very, very important that the judiciary does not interfere in the power of the people and the political processes. Now that has serious implications to think about. The third point, the fifth point is on the doctrine of jurisprudence and the use of jurisprudence. Roe versus Wade, once overturned, seems to throw away important jurisprudence. And this jurisprudence has been very critical. Now for us, with common law systems where we follow jurisprudence, that could have serious implications. Some of the others that I've been thinking about as we are having this conversation here is the impact of globalization itself. If CNN has news these days, news item number 4 is on abortion and Roe versus Wade. Fox makes it almost news item number 1 or number 2. So the impact of globalization and the conversations and the normalization of some of these conversations around termination of pregnancy could have both a good effect, but also a very bad effect. And then the other one that I want to leave with you to think about is, what does this mean for our constitutional cases in other countries? When they say privacy can actually be used to advance the right to abortion, and then they overturn that, what does it mean here? There was a conversation on vagueness of health, vagueness of life. I know part of the cases we've filed are around standards and guidelines. Standards and guidelines are just clarifying what health and life means. And therefore, if you question the constitutionality of a vague title called the life of the mother or life of health of the mother, it becomes something to think about. And then lastly is the whole question that this means for decolonization. I think that the whole world is moving away from coloniality and overthinking about our history in a colonial manner. I don't think that our judges have moved to the extent of decolonizing their minds, that they cannot be persuaded by the Roe versus Wade. So the serious implications there are around just what the chilling effect would be on some of the conservative judicial systems that are still existing in some countries. Thank you very much, and I hope that that helps to inform the conversations.
Thank you, Mr. Mlumba, for that elaborate and eloquent submission, in addition to the conversation that we are having. One of the things that I hear you say is the opportunity that this case might open for us. I think looking at it in that sense of having the opportunity to discuss further the decision, opening up the conversation around the caveat and what protection of life and health means. And you also raised some issues that weren't raised before in terms of masculinity, patriarchal influence on the judgment that we have, and of course that influences both even in the other jurisdictions and also in our country. And I think that also the opportunities that we have at regional level. We've seen, of course, in Kenya that they are, besides the Roe versus Wade and whatever is going on, they have progressed to reaffirm abortion as a fundamental right within their constitution, and that gives us hope. I will not belabor, because of time, to reiterate what has been clearly communicated in terms of giving us context for the legal aspects. And I think the other thing is, really, you have indicated to us how many cases have come even after Roe versus Wade, and also calling us to think about maybe the opportunity of consolidating the cases that we have as partners within Uganda in terms of the abortion, access to abortion and the interpretation of the same. So thank you again for that contribution. I know that you'll be running off, you might not be able to stay. I wanted to give an opportunity for you to answer one of the questions before you leave. And this question is from Lawrence Kayondo, who asks if the proposed law by the coalition, I think he means the partners within the coalition who have brought who have taken to these cases to the courts of law, if they were passed, the proposed law was passed in Parliament, which bills and law do you suggest could help the cause? Over to you.
Thank you so much, Anne. I don't think I understand the question well. Does it touch on the law before
no,
the Ugandan Parliament or the US Parliament? It's not very clear.
Yes, but I think the participant means the law that is proposed in terms of what is envisioned in our constitution that the members of parliament are meant to pass. So if it's if it were to be passed, which bills and law do you suggest could help the cause? It's not very clear, but maybe Lawrence, if you could unmute yourself and just clarify on that question.
Thank you so much.
Yes, go ahead. Go ahead, Mr. Mlo. I don't see.
Thank you so much, Anne. I don't know how this rhymes with the conversation on Roe versus Wade, but I think what we've been looking up to as a country is progressiveness in laws around access to safe and legal abortion. So the proposed law itself is very useful. And if you are discussing it in the context of Roe versus Wade, I don't think that we should be persuaded by the negative consequences of Roe versus Wade. Unfortunately, that's my thought. Our parliaments don't think that way. If Roe versus Wade overturns, or if the current decision by the judges overturns Roe versus Wade, it will be the members of parliament here that will bring it to the floor of parliament to use it to even challenge the law that has been proposed. But the ideal situation would be a positive direction, like what countries like Kenya have actually done, to really constitutionalize some of these rights in a more firm way. Ensure that in the next constitutional amendment, sexual reproductive health and rights are provided for comprehensively, as we've seen in other countries. It should not be new. And then once the Constitution has provided for comprehensive sexual reproductive health and rights, any legislation that is proposed and that is not retrospective or retrogressive would be very useful in advancing sexual reproductive health and rights, including the right to safe and legal abortions. We are not necessarily, we may not necessarily be persuaded by the US decision, but as I've indicated, our systems here are lazy, a bit lazy. They don't move out of context, and they have not moved out of the decolonization that we are going through as a country. I hope that helps.
Thank you, Mr. Mlumba. I think it does. At this point, we will be going into our second respondent, who was going to give us the context from Rwanda. I know that Rwanda has made some steps towards decriminalization and also in the historical presidential order that released the women from being incarcerated because of having abortions. So we would want to hear from your end, what would this overturning this case imply for the Rwandan, within the Rwandan context? Thank you. Our respondent is Mr. Christopher Sengoga, who is the Executive Director of Health Development Initiatives, which is located in Rwanda. So welcome, Mr. Sengoga.
Thank you so much, Anne. I'm actually director of the Center for Health and Rights, not executive director. Hello, can you hear me?
Yes, apologies on the title. Yes, we can hear you loud and clear.
No, it's fine. It's actually fine. Thank you so much for this opportunity. I was able to listen to both the previous speakers, and I would really like to thank Asia and Moses. At least Moses has tried to explain in details the context of the case and how the case so much closely connected with other cases in regards to abortion. Coming to the Rwanda's context, I would say that it's not really far from the cases of advocating for access to safe abortion in Rwanda is not really far from jurisdiction of other countries. And the fact that, of course, many African countries, laws that regulate the penal laws mostly 10 years back, and I believe even of the current, some African countries have laws that were inherited from their colonial masters. The same applied to our country, Rwanda. And I would say that for cases of access to safe abortion in Rwanda, before the coming of Belgians and French around 1923, it was actually a crime that really didn't, where women who committed abortion, one was taken as an abomination, and for those who, young girls who were pregnant could be, I don't know how I can even term it, because they could be taken and be thrown into bushes, especially on the context that they would cause shame to their families. They are coming Belgians in 1923, then they brought us a very good penal law, which we used up to 1977, and that is when it was separated from being a penal law for Rwanda, for Burundi, and Democratic Republic of Congo. So it now became a Rwandan penal code. It only allowed abortion for one condition: to save the life of the mother, which I believe has been the case in many other countries, not only in Africa, but across the globe. And then, of course, civil society organizations, human rights activists, feminists had to stand up since 2009, at least, to see that advocacy is put on the forefront to advocate for a better and inclusive legal environment for women to access a safe abortion. And Rwanda was lucky that at least in 2012, the 1977 Penal Code was revised, was amended. And then one condition was extended with 3 additional conditions, allowing women and girls to access safe abortion. For saving a woman's life, now the 3 other conditions were rape, incest, and forced marriages. But of course, the Rwandan parliamentarians don't differ from the rest of African and global lawmakers, who mostly, in most cases, they are conservative. And talking about abortion itself from a moral perspective, a religious perspective, not from a human rights perspective, has been, I think, the most difficult discussion to encounter in any society. So when they revised the Penal Code of 1977, they just, in 2012, 4 conditions. The first, second, and third conditions, we are subjected to securing a court order. And those were incest, rape, and forced marriage. Any woman who was subjected to any of those conditions was supposed to go through the court process to secure a court order and then take the court order to the hospital to get abortion. And since 2012, when the law was revised up to 2016-15, we only witnessed 3 cases that we are successfully passed the test in courts. And you can imagine how many women who were subjected to rape, incest, and forced marriages. There were more than 2,560, and those were just few recorded cases. So we could imagine how many didn't really come up to report the cases, to disclose the information that they have been subjected to rape or any other sexual violence that at least qualified them to seek for access to safe abortion. And in 2017, we had to again now pick up the fight again to do advocacy, engage members of parliament, showing them the evidence that the court order requirement cannot work. At least we had gone to court and we had 3 cases. And I'm happy that I've seen CRR part of the conversation, that at least we worked on a case of Atete when I was still working in grid with CRR. A 14-year-old girl who was subjected to defilement, and the alleged perpetrator went missing to date. So the mother found out at the 4th month that her daughter was, 14-year-old daughter was defiled, she was pregnant, and then she had to go through the onerous, burdensome conditions, getting a lawyer, going to court, seeking court order. In brief, the young woman ended up getting a court order when the pregnancy had advanced to the 8th month. And when she went to the hospital accompanied by her mother, the director of the hospital explained to them that he's not really going to induce pregnancy. Rather, he's going to do all the measures, and the young woman is going to give birth. And the baby will be, the fetus will be alive. And then the family will see what to do with the fetus. So in such hard time, the mother decided to move away from the hospital with her daughter. So they left. And after almost 1 month, the daughter gave birth. So that was one of the cases where we could stand and before the law, the legislators, the policymakers, that this can't work. At least we need to move away from court order requirement. And we are lucky that at least in 2018, the court order requirement was removed. And then as Mr. Moses was explaining, going to court, you have a woman who is pregnant and she has been subjected to rape. Then the alleged perpetrator must be has to be accountable. And you know, the appeal, the legal process can go beyond 9 months, can go beyond 1 year, and the pregnancy cannot wait. And in most cases, you find that whenever the advocates on behalf of women who were seeking the court order to get abortion, they had to always intercept and meet the prosecutors who are, I think in Uganda, in other jurisdictions, I think they are state attorneys. So you could find that the prosecutors themselves don't even understand why access to safe abortion is needed in the first point. And then they could also overturn it to argue that when you look into Article 14 of the Maputo Protocol, it talks about a woman. And now coming back to Rwanda today, to our context, you could find that when you talk of a woman in our local context, it means someone who is elder, they are of a majority age above the age of 17, from 18 and above. And then the fact that a 17 or 14-year-old girl has been subjected to defilement could not qualify to have access to safe abortion. And whenever the lawyers who were understanding at least that access to safe abortion could be interpreted looking into our constitutional provisions, the laws that protect sexual productive health of human being in Rwanda, and also the child rights. So you could find a confrontation where judges don't understand that access to safe abortion is part of fundamental human rights, as Moses was explaining. And also looking at this 14 or 16-year-old girl, that her life is at stake. And even interpreting right to health and right to life together, that it has a close connection with access to safe abortion. And then, at least in 2018, we could see a shift, could see that the legislators, the policymakers, whenever you could convince them with the case, a failed case of a 14-year-old girl, we saw a political willingness after understanding that at least court order requirement cannot work. And then the law was at least somehow conducive, if I may quote that. And in 2018, the law was again for the second time reviewed or amended, and they extended now conditions from 3 almost to 5 conditions. And currently we have, owing the fact that abortion is still a crime and is allowed under exceptional conditions or cases, at least we have a condition where the law states that if a pregnant person is a child, and the fact that the only children who would get pregnant are girls is one condition. The second is rape, incest, forced marriage. And the 5th condition is the one that persistently has been there since 1977. So I would say today we still have challenges in implementation. And the challenges are so connected to the law and what the case of interpreting access to safe abortion from a moral point of view or a religious perspective, which makes it vague when it comes to healthcare providers, the community stigma, the judgment, and the shame that women carries whenever their information is linked outside that they have been seeking or they sought to have a safe abortion. For the implication of this case to the Rwandan context, I would say the biggest opposition we have in Rwanda for sexual productive rights is not actually the donor jurisdictions, but rather the Catholic Church. Because in our country, they actually own and operate 40% of health facilities. And in 2012 and 2018, the Catholic Church confidently issued a directive that their facilities will never provide modern family planning and safe abortion services in their facilities. So you can imagine, and we have found that we have 30 districts in Rwanda, and almost 6, if not 5 of these districts have hospitals that are being operated by Catholic church. So you can imagine those women from those districts, they have to travel miles and miles of kilometers to seek safe abortion. And I would conclude by saying that the impact of the case would be anticipated to restrict the funding of sexual reproductive rights interventions in Rwanda. I would see that the threat is more visible in funding processes, where even in 2019 and 2018, HD actually lost some funding from Palladium because the contributor of the funding was a USAID fund, which does not, of course, fund interventions to do with abortion. So I would say that the impact, the possibility is seen on the funding rather than the implementation or the processes to advocate for access to abortion in Rwanda. And one thing that would come back to a little bit is about the laws. At least Rwanda has taken the move to amend all laws that were inherited by our colonial masters, and the move started around 2018, where almost 75% of the laws have been amended to suit the Rwandan context, looking at the culture, looking at the background, looking at the history, which I believe is a trend or a shift that at least we can say, or we can attribute to political willingness that comes into play with our constitution, which reflects so much on the rule of law. Yeah. I think, I believe I should stop from there and say that because of this political willingness that has been seen in reviewing laws, amending the restrictive provisions, has been the one that's at least motivated screening of how these women go to jail, how these women are imprisoned because of abortion and other sexual reproductive health related crimes. And this has made our government receptive to the extent that our president has pardoned women, more than 300 actually women, 3 times since 2019, 2016 in December, 2019, 2020. And this is because these women who are found in prison, as the previous speakers alluded on, they are women of from humble families. They are women who are poor. They are women who cannot afford to pay for access to safe abortion-related costs. And then they end up going into quacks, into unprofessional providers, which of course puts them at risk for their health and life, and at the same time to be arrested once they have been found on going into the processes of unsafe abortions. So I would say I would stop there and welcome any question or comment or any need for clarification. Thank you, Anne.
Thank you, Christopher. I think that's a very important context that you have provided for the Rwandan partners. And I think one of the things that you highlight is the fact that prosecutors within the Rwandan context do not understand. So there is a challenge within the judicial system, which makes it difficult for these cases to find positive ruling, and maybe that would impact from the fact that the Roe versus Wade overturning it would be further influencing or impacting on the views of the judges and the prosecutors within the country. And I think one of the things that we share from what you have alluded to is that the influence of a moral point of view, beliefs and values versus the human rights perspective. But again, I think that the Rwandan government and partners indicates the political will, which is an opportunity that the country can still ride on to have that progress. And also, I think we are encouraged by our neighbor, the Kenyan counterparts, who have made more progress in terms of their legal and policy around access to safe and legal abortion. At this point, I want to request or indulge the participants for just a few more minutes before the call ends. There were about 2 questions that were raised, but in case there is any other, I'd give an opportunity to participants to raise it. So I will just go to the questions which have been raised and put them before our panelists who are still on call. That's Asia and Christopher. One of the question is from Carol Besemira, where she asked, do these rights cover young girls in the village between 13 and 17 who fail to return to school because they are now mothers? And then the second question, that question is not very clear though. Which rights are we speaking to? So Carol, if you could make that clear, because I don't know which right, these rights cover the young girls in the village between 13 to 17. Do you mean access to the abortion rights? Do you mean what right? So just make that clear. And then, but also I think there was a conversation, a discussion from what Christopher was talking about, where he was referring to teenagers or people who are below 18, and when they get pregnant or they are defiled. So it could be in line of what Carol is talking about. I will leave that. I'll give that to Chris to respond. And then there's a question from Dorothy Amron, which I'll give to Asia to respond. And she asks, does the feminist foreign policy bring any hope? Remember, there was a conversation earlier on patriarchy and how that influences the decisions that are made even within our courts of law. So the question is, does the feminist foreign policy bring any hope? Over to you, Asia and Christopher. So Christopher, you could go first, and then Asia would answer the next question.
If I've understood well, it seems that the first and the second questions are related. That you have allocated to me.
Not necessarily. Besemera is asking whether these rights are accessible for people who are under the age, that's the age of 18.
Okay.
So who for whichever reason face, whether they've been defiled or face these, they are faced with abortion, unwanted pregnancies.
And then the second one?
The second one was whether the feminist foreign policy brings any hope, and that's to Asia.
Okay. Yeah, maybe for clarity, I'll explain that the current law we have, of course, restricts access safe abortion to only 5 conditions. And one of the conditions is that the pregnant person is a child, and a child by the Convention on Rights of the Child is every person below the age of 18, which applies to our jurisdiction also in Rwanda. So this means that any girl child below the age of 18 who is pregnant, regardless of how she got pregnant, she has an absolute right to access safe abortion. And looking at the ministerial order which regulates the conditions upon which this child should request for abortion, it stipulates that if a child is the one requesting for access to safe abortion, of course from the health facility, she has to be accompanied by a parent or a guardian who should sign the consent on her behalf. But the ministerial order kind of understood the context, the culture, the background, the stigma based on a religion and the moral point of view, and further explained that if the parents or the guardians their wishes are not really in line with the best interest of the child, then the best interest of the child should prevail. Which means that if the parents or guardians are not supporting this young woman, this child who is seeking safe abortion, then the provider should ask the child her best interest. And if her best interest is to have abortion, then the provider will go ahead, make her sign the consent, and provide the service. But of course, as it reads, as it is written on paper, it's really, if you hear it, if you read it, you find it's really making sense. But sometimes when it comes to the practice, it becomes somehow difficult that the decisions are not normally made at the health facility, they are made at home. So if parents or guardians say no, we've seen cases where these young girls don't even dare to make a step to go to the health facilities. But we would say currently the law is clear. The way it is written is really clear, and it protects, it gives absolute rights to these young mothers to have access to safe abortion. Yeah.
Thank you, Christopher. Just to again make clarity and the fact, I think that that's a good progress on behalf of the Rwanda. But I know that in our country it's not the same. It's that law is not the same. It just says to save a mother's life, and it doesn't refer to any age. So it is a blanket to save a mother's life. So, but again, from the conversation that we had with the earlier respondent, Mr. Mlumba, where he said the interpretation does not have to be limited. So maybe in our case, the interpretation of that what it means to save a mother's life would come into play. For instance, if a 10-year-old is being defiled and is pregnant, would that for her, would that access to safe and legal abortion be saving her life? Probably it would pass in the interpretation, but that's left to, it's not clear in our context. Over to you, Asia, for the second question, and then we will be.
And I think I should, there is also this one, I think I should also combine it and end with same time.
Please go ahead.
There's someone who has asked, is it Dorothy? Can both abortion and reproductive rights be considered they are underage? Yeah, I think that is what I answered. So there is one that asked whether the great strides in Rwanda, so has there been an increase in service demand, and is data freely publishable? I would say yes, but we are still struggling because looking at when the law was put in place in 2018, I've seen a shift, I've seen a trend, and I've seen an open conversation and public discourse where people at least can 2, 3, 5 gathered can talk about access to abortion, which never used to exist, owing, of course, to the fact that sexuality still remains a taboo. But I would say we have seen the progressive increasing of numbers of women who have heard about information on that access to safe abortion is available under the conditions set by the law. And for the few numbers I've seen in organizations that are running a toll-free hotline, I've seen that in 2019, when the ministerial order that puts conditions upon which a doctor should satisfy to provide abortion, in 2019 around April, I've seen that the whole year, HDI received 59 cases of women who were seeking information and referrals to go to health facilities for abortion. And in 2020, I've seen a tremendous increase from 59 cases to 449, which is a big move. And currently in 2021, we've seen a record of 722 cases. So when it comes to data, it's still challenging because the government, the law puts a restriction to other providers on and puts a medical doctor and a hospital facility to be the only ones to provide safe abortion. And yet some women would prefer to go into private facilities, clinics. There are some clinics who have gynecologists, trained ones, who can even provide safe, but we would say safe abortion, where women don't want to go through the processes that the government hospitals normally subject them to. Go first go into consultation, go into this, and all those. I've seen that these private facilities, whenever they provide safe abortion to these women, of course, who can pay out of pocket, you find that they don't report the cases to the ministry because they are doing it illegally. Now, which makes it very challenging for the data to be accurate and be published when it is really trusted. Yeah. Thank you. And
thank you, Christopher, for that addition and providing more context in that question. Over to you, Asia, for the last question. Then we will wrap up. You can also give your closing shots after answering the question.
Sure. Okay. Thank you. And thanks so much to all the participants, not only Christoph and Moses, but all of the 60 and more people who have engaged in the conversation. and in the work. I mean, Dorothy, yes, I think there is reason for hope, in part because while, we'll see the damage that this ruling will make in the coming days and months and years, we also just have to look around at what's happened in other countries to find reason for hope, particularly in the context of Latin America and the Caribbean, but also right in our own backyards. And I would argue in Uganda as well, despite setbacks. So there is definitely reason for not false hope or childish hope, but actual concrete evidence-based hope. But of course, there will be massive setbacks because the stakes are so high for those who do not want to see changes and reforms to laws and policies. So I think, we have to be even more nimble, even more resilient, even more strategic as we move forward. But yes, there's definitely cause for hope. Thank you.
Thank you, Asia, and thank you for closing on that note. Indeed, there is hope. All is not lost. I think that should be our reason for fighting on, and to know that there are opportunities beyond this for us to continue our fight, which we have seen or realized the small successes. We can still go strong and continue to ensure that women and girls have equal rights to access self health rights and health justice. At this point, I just want to thank you and extend our vote of thanks to our keynote speaker. Asia, thank you so much for contributing to this conversation and highlighting the context, but also giving us the opportunities where we can where we can do more and put in the efforts that we require, and calling us into solidarity as partners to the cause. Thank you, Christopher, for adding that context, and also for showing that at regional level there is hope and we can continue the fight towards ensuring that women and girls within the Global South have access to sexual reproductive health rights without discrimination and without the legal framework being a barrier to them. Thank you to the participants, everyone that has been able to stay on the call past the time. Thank you for enduring and staying and contributing through the comments. We have taken note of the comments that you have made within the chat, and for the contributions and for the questions. Thank you again, and I wish you a good evening, a good night probably to Asia, or a good morning, and whoever else within different diasporas. Thank you, and God bless you. You can leave at leisure. I will ask Grace to play for us a beautiful music as people leave at leisure.